Okay, this is Pops on my page, Legal Reform. I was telling you before, legal reform is nothing but legal resources for making a change in the legal system. I give you a bunch of laws that aren't mentioned, aren't used, and rarely enforced. And then I give you ways to have it resolved. I give you government agencies to help you resolve your case. And I keep explaining the conspiracy to deprive rights under the color of law and how often that happens. Sorry. Okay, so here's that one, informed consent. It's a legal requirement. I just put that one on TikTok and here. This is an easy way out. Not to mention a few others that I posted. Dismissal is the only remedy for denial of a defendant's Sixth Amendment speedy trial. You can actually have your case thrown out, dismissed, or reheard based on a lack of speedy trial. You guaranteed a speedy trial. I think it was the 5th. I forgot. But anyways, you're guaranteed a speedy trial in the U.S. Constitution. And the limit to that is 90 days from the time you first appear in court or when the paperwork's first filed or arrested. So from that point on, they got 90 days to give you a speedy trial, but nobody will tell you that. Nobody will see to it that you get it. You don't get it unless you ask for it, just like everything else on legal reform. You won't get effective assistance of counsel unless you demand it, and you're going to have to go over the rules and the codes with the lawyers and the judge in the courtroom to make sure everything is played by the book, so you don't get cheated out of effective assistance of counsel, due process, your constitutional rights. And you actually, I have people now been doing it for a while. Sometimes it works, sometimes it doesn't. But most of the time, when you bring up the rules and the codes in courts, judges will talk over you, lawyers will talk over you. They'll act like they don't know what the hell you're talking about, because most of the time people do it. They don't take the rules and the codes with them and instruct the judge and lawyers and, the jury, that you want it by the book, as prescribed in the Rule of Professional Conduct and the Code of Judicial Conduct, is what gives you due process. That doesn't play out. You didn't get a fair trial, and you definitely didn't get due process. You didn't get effective assistance of counsel. Okay, so either way, sometimes people like to put comments. This is a public page. The only thing you spend here is time, no money. I don't care if you like it. I'm just trying to inform you, encourage you to look these things up yourself. I look them up for you and read them to you. Okay, but in my comments here, I started legal reform because there was a lot of lawyers and giving disinformation, and I was making comments and throwing laws at them, and slowly but surely they were disappearing from my feed. I don't know if they were blocking me or whatever. This guy jumps on. He says, yes, it is unfortunately, it's not the reality when you have an overzealous prosecutor only interest in conviction, in conviction courts, not justice. Well, that's an immediate violation of Rule 3.8, special rules of prosecutor. It says they can't bring forth a case they can't prove, but they'll do it anyways. And they'll get assisted by your attorney, whether it be a public defender or a private attorney, by not giving a quick and speedy trial. You won't get a probable cause hearing. If you don't get a probable cause hearing, they'll shoot straight into a preliminary hearing, and that'll move you on to trial, and there'll be massive amounts of continuances. But it's not just the prosecutor, it's public defenders. They work in conjunction. I've seen public defenders and helped them stop people from signing signing off on so they could leave court. Here, sign this and you can leave. It's all over. What the people didn't know, what they were signing was signing their freedom away. They were signing a piece of paper saying they were leaving there with a Class X felony. So I made this a relevant point to a lot of defendants, and the public defenders would get mad and sometimes yell at me, threaten me, go tell the judge on me, tell the state's attorney on me, and I didn't really care. I got chased out of a lot of different courtrooms. 26 in California, used to be one, 13th in Michigan, and they moved that court to, I think, State Street and 11th, 51st in Wentworth, some cases in civil court. But anyways, I used to like to travel around and explain people the rules, the codes, legal responsibilities of all lawyers and judges. So this guy puts, overzealous prosecutor. It's not just the overzealous prosecutor. It's the public defender. It's the judge. Nobody's seeing to it that you got a quick and speedy trial. Nobody's seeing to it that you got a probable cause hearing. There's a judge right now in Texas. It's internet famous. Everybody's talking about it because a gentleman walked into court. He didn't have a lawyer. The judge told him, just shut up. We're going to have a probable cause hearing. And then he started talking to the cop, and the state's attorney found there was no probable cause and threw the case out. But that was a conspiracy between the public defender and the state's attorney. Well, he didn't have a lawyer at the time, but if a public defender had stepped up, he wouldn't ask for a probable cause hearing. The state's attorney wouldn't, and that's the law. But nobody is going to bring it up, and it's not going to happen. So I tell Paul, true, but ever hear of a motion to quash, vacate, dismiss? And so if you want to file for violating your constitutional right to a quick and speedy trial, you can throw that on a motion to quash, a motion to vacate, motion to dismiss. Okay, they're kind of different depending on what state you're in. They constantly like to change the names. Okay, but Paul said, or I tell Paul, but true, every motion to quash, vacate, dismiss, since when hasn't an attorney had the tendency to break the law? If you watched the video and looked up what I was talking about, you could actually do something and make a change. I bet you didn't look at the other useful laws and remedies I posted. Try looking at the one about the conspiracy against rights under the law, which is basically what you're complaining about. I posted legal remedies, all of which is at your disposal. Do something or simply complain on social media. So Paul here tells me, very familiar with the law. It's my 37 years of plus experience that proves my point. Check me out at American Litigation Consult.whatever.com. So I put, so then you know how easy it is to prove the conspiracy against rights under the color of law. I figured that out in 1979, which gives me 10 years advanced knowledge on this than him. Got a few cases thrown out on that. You do you and I'll do me. If you like, I could explain it to you. I mentioned it numerous times in different posts, and I'm not the only one talking about it. The term under the color of law is what you're used to dealing with. I'm used to exposing it. Okay, so here he goes with this little link here. Announcement. Welcome. We are offering free access to our legal resources page for all our visitors, especially loved ones that are incarcerated. I believe passing on the blessings and giving by God and others. Learn more. I ain't even trying that. This website uses American Litigation Legal Consultant. Legal expertise you can rely on, especially on federal state litigation. So he's quite familiar with the conspiracy to deprive rights under the color of law. American Litigation Consultant LLC is an internationally known for widely acclaimed consulting service. We search and investigate cases at pretrial to post-conviction. I've filed most post-convictions for people. Actually, I had them do it, and it was based. I did it. I wrote it up, and I use a conspiracy law, conspiracy to deprive against rights under the color of law, and followed through with that. And it's you can look up post-conviction relief. Okay, assisting defendants, inmates, and their attorneys. Okay, so basically this is a guy advertising on my page. And by doing what he's doing, he's furthering the conspiracy against rights under the color of law. He's offering to defend you from that, but he's not telling you exactly what's going on. And that's what I'm doing. I'm doing it for free. Not that I can't use money. I'm broke. I'm a poor old man, handicapped, living off SSDI, and even before that, I just use what I got to help you out. And with me, the only thing you have to spend is money. That guy's probably operating on a contingency basis, but he'll want you to go through a lot of information with you. But see, it's easy to prove a conspiracy against rights under the color of law when you cite all the violations and the rules and the codes. And as I told you before, reporting misconduct is mandatory both in the rules and codes, which makes it easy because nobody abides by the rules or the codes. So you cite the attorney for ineffective assistance of counsel, the opposing party or state's attorney for violations of the code, starting with fairness to the opposing party, or Rule 3.8, special rules of the prosecutor, or special responsibilities of the prosecutor, and also cite the judge for judicial misconduct. And you don't even need exculpatory evidence because when the guy got out of prison, I didn't have anything. All I had was the case number, his name, Illinois versus, I don't even remember his name. And I put in for bond, for an I bond. He didn't have any money, and he was out in a couple of weeks. I threw the rules in there, a couple of rules, expediting litigation, being diligent, that would be competent, to rush things along. So that way it doesn't sit in court. If you use the laws correctly, things will move along swiftly. And Paul Tellini, your 37 years of experience that proves your point. You just prove my point on the conspiracy against rights under the color of law. In the rule of professional conduct, it does state that, like I mentioned to you about informed consent, it does tell you in there that the legal system is supposed to keep you informed and abreast. You read the preamble, and you'll find a lot that he isn't talking about. He isn't talking about the rules. See, I'm explaining to you everything that's going on in the court of law, things that shouldn't be happening, things that are happening. I use Constitution, state laws, whatever is needed. And eventually I'm going to start posting videos where and how to sue, and you'll have all the grounds. The conspiracy to deprive rights under the color of law. It doesn't matter what court you're in. It doesn't have to be criminal court. It doesn't have, it's Every court, the rules of professional conduct and code of judicial conduct are the key common denominator in every court. They are universal in every court, state, federal. It doesn't matter. And so this guy with his 37 years of experience, So people, if you talk to him, if you want to call him, and see if he helps you out, or he will help you out, be sure to go over the rules of professional conduct to know his legal obligations to you, okay? And then you can question him about all those laws in a court of law, the rules and the codes. And he's required to be honest, forthright, show some integrity, diligence, morals, scruples, ethics. Okay, but like I said, and you talk to any attorney, know the rules. Print them out, highlight every issue you want to speak on, because every court's different, so all the rules don't apply in every court, but all the rules apply for every court, if you can understand that, okay? So you're not going to use every rule and every bit of the preamble or the scope to note the violations in your case. But see, every case has violations in the rules and the codes. Simple as that, okay? But so if you want to talk to Paul Tellini, go over the rules of professional conduct, the code of judicial conduct. Be sure to brief yourself on the conspiracy against rights under the color of law. Okay. And don't forget to use the letter of the law. Letter of law clearly states, in any interpretation of the law, one must go word for word to the letter. It's mandatory in interpreting the law. So what you see is what you get, so that way we all hear, see, and say the thing. Okay, so if Paul wants to pursue some legal action, this is on the internet. This is on Facebook. This is a public page. Nobody has to pay to come here. You don't even have to like. All I want you to do is learn the law as much as you can, because you'll never have a fair trial, you'll never have effective assistance of counsel, you'll never get due process unless you learn the laws and quite, for the most part, become a lawyer and get a degree. It's never going to happen. It's never going to happen. Okay, but so see, Paul even liked it down here when I put him down here. I'm not the only one talking about the term under the color of law is what you're used to dealing with, and I'm used to exposing it. He's used to dealing with it and defending it because it's easy to defend. And once you bring that up to any lawyer and judge, if you're going to sue them for conspiracy to deprive rights under the color of law, there's no defense to that. There's no defense. So you can ask for a summary judgment. And you ask for a summary judgment, that's just a term used to say, hey, we have no defense, so we're just going to offer some money, Or your lawyer could file it, or you could file a summary judgment. You don't need a lawyer to file a summary judgment, and that just tells the other side you have no defense, because there is no defense against a conspiracy to deprive rights under the color of law. There is no defense. So the only choice they'll have once you file the summary judgment is to settle out. And I would strongly suggest you negotiate. Make sure you do some research on what you can get. If not, hit me up. Just send me a message at Legal Reform, and I'll walk you through what you need to. I've spent hours with people on phone calls, texting, sending them links, sending them laws, resolution, And remember, the FBI and the DOJ has a special unit within their civil rights department that specifically deals with the conspiracy to deprive rights under the color of law. I'm going to do a video on that next, okay? Showing you where, and some videos I showed you about filing complaints and different ways you can sue, different methods you could use, different government agencies you could use to help you along. Okay. And one more thing, since I was talking about Rule 3.8 special rules of the prosecutor, it's every prosecutor's job, no matter what state you're in, or no matter what court, federal or state, it's mandatory for every prosecutor, if they come across evidence, knowledge that a defendant was innocent, it's their job to exonerate them. Okay, because a lot of people ask me about, if I can find a lawyer to help them, and they don't have a lot of money because, most of the people I talk to are poor folks like myself. And as I tell them, save your money on a lawyer and don't go alone, because they get upset. They don't like you bringing up the law to them. Can't tell me how to do my job, they'll say, but as long as you take their job description with you. Because violating, if they don't do that, that's a furtherance in the conspiracy to deprive rights under the color of law. And you can report that to your state's attorney general, U.S. attorney general, the Department of Justice, the FBI. They all have their civil rights divisions, okay? And you can file complaints with them. But you got to be very specific and start off with stating, that division it clearly states we are here to help you with the conspiracy to deprive rights under the color of law. And all you got to do is state the laws like I do. Okay? I'm doing my best to help you out, there was never anybody there to help me. That's a bad feeling, That's a bad feeling, especially when you know all this, and you figure it out that it's just the whole damn system. You're fighting the whole damn system. And you're fighting against everybody breaking all these laws. Nobody's going to want to admit to it. But once you put it down on paper, remember, you can do this electronically. You can be in Florida and file in the state of Illinois electronically. You don't have to be in the state, okay? So you take care, be careful. Nothing but love for you. God bless and good night.